Estoppel. You've heard this word a lot and know it applies to labor relations in your collective agreement. But how? Estoppel is a legal rule that prevents a person from going back on their word, particularly with respect to a contract, or in our case, a collective agreement. When does it apply? An estoppel is generally created when one party makes a promise, which can be verbally or by conduct. Two, the promise is relied on by the other party to their detriment. And three, the party who made the promise is now trying to break that promise. Here's a quick example. There are strict timelines to file a grievance under your collective agreement. The collective agreement states that if the union misses a timeline, the grievance is lost. Oh no. The employer and the union have never enforced these strict rules. There has been a consistent past practice of missing timelines without any consequences. The union filed a grievance outside the timelines, which has never been an issue before. But the employer has now changed their mind and says that a missed timeline means the grievance is lost. As this is completely unfair, the union would argue that the employer is stopped from relying on the strict language of the collective agreement and the grievance is not lost. They would say, 1. By virtue of never objecting to missed timelines in the past, the employer made a promise to the union that they could miss timelines without consequence. 2. The union relied on that promise and the past practice when they filed a grievance outside of the timelines. 3. The employer is now trying to break that promise, which will have a serious negative impact on the union. In this case, the union would have a good estoppel argument against the employer, and an arbitrator would likely find that it would be unfair to change the past practice and punish the union. An arbitrator would likely conclude that the grievance is not abandoned. Woohoo! That's great, but how do we end past practices that we do not enjoy? A past practice can be brought to an end by reasonable notice. But what does reasonable notice mean? For parties to a collective agreement, typically this means that before a collective agreement expires or during collective bargaining, either party can advise the other that an established practice is at an end. To ensure there is no confusion, the union or employer will provide the other party with a notice of end of past practice letter, which lists the past practices and lets the other party know that they are at an end. This gives either party the chance to bargain language in the collective agreement if they want to keep the practice. Otherwise, the strict language of the collective agreement will be followed upon ratification of the amended collective agreement. This is a complicated area of law, and this video is simply a high-level explanation. If you have any questions about estoppel, past practices, collective bargaining, or template letters, please contact our office and speak to one of our lawyers. Watson Palmer Labor Lawyers.